Well, good afternoon, everyone, and thank you for joining our signature series today. We have a special guest, Jamie Walker, who will be teaching us about Nevada probate for real estate agents. So I'll give a brief intro to Jamie and then hand it over to her. But before I do that, I just wanted to remind everyone that if you do have questions, I will monitor the chat. So please go ahead and drop your questions in there, and I'll make sure that we get those questions answered throughout the class. So Jamie joined Alling Jillson in 2014 and became an equity member in 2021. She's a native of South Lake Tahoe. Jamie graduated from the University of Nevada, Reno, and then received her JD with distinction from the University of Pacific McGeorge School of Law. During law school, Jamie was inducted into the Trainer Honor Society, worked as a certified student attorney at the Federal Defender's Office for the Eastern District of California, and was a team leader at Victims of Crime Legal Clinic. Jamie focuses her practice in estate planning administration and business and real estate transactions. So without further ado, Jamie, take it over.
Good afternoon, everyone. Again, thanks, Jessica, for that introduction. And today I will be presenting on Nevada probate for realtors and real estate agents and brokers. I'm sure, as I see, I've worked with many of you before, and for those of you I haven't, as Jessica said, was born and raised in South Lake Tahoe, and then have established my practice here, first starting in the Valley and then moving up to Tahoe to be here with my husband and daughter. And so I have been focused on real estate and primarily probate and estate administration through estate planning practice for the majority of my career here at Alling Jillson, which started in 2014. So this course is just intended to be a primer and to be helpful to those of you entering into contracts and listing agreements where probates are involved. And so moving on to really what we're going to talk about today, and that's really looking ahead of time and at the beginning of everything on who has the authority to sell, right? Whether or not court confirmation is required. What should your contract say at the very beginning when we look at the listing agreement and then the purchase agreement? And then how, as agents, do you keep the transaction moving? Real estate is not simply just a conventional listing with a deceased owner. The agents must identify who is authorized to sell, understand the scope of that person's authority, and coordinate really the transaction with probate counsel if there is any, title and escrow, appraisers, heirs, and creditors. And so really the goal of this presentation is not to turn agents into probate lawyers. That's my job. It's to help agents spot issues early and know when legal guidance is required. So really looking at the learning objectives here, the practical focus is intake and transaction management. So agents should be able to leave this course with a repeatable process for deciding whether or not a listing is ready, conditionally ready, or not yet ready to bring to market. And so by the end of the program, what I want you to leave with is when you are able to recognize when a property may require probate, and you want to identify the person who may sign the listing and sale documents, and then distinguish really, and this is an important one, whether or not there's a court supervised sale or an independent administration with no court approval is necessary. And in each and every listing, we want to look at the appraisals, the notice requirements, when approval is necessary, and then title and closing issues. And then what I'd like to help you identify is common licensing and transaction management mistakes. So, of course, I have to tell you, limited liability in my presentation, right? This presentation is for educational purposes only. As you know, probate procedure varies by state, county, judge, court order. And so really what you are looking for, I'm licensed in California and Nevada. I think most of the agents, right, at Chase and through Signature Title deal with properties in California and Nevada. So agents, right, it's not your job to interpret a will or determine heirs or give legal advice. What we do want you to be able to do is confirm authority and sale procedure with Nevada Probate Council and title and escrow, or California if necessary. And so really, licensee should stay within the real estate role. Nevada law, specifically Nevada Revised Statute 645-254, right, make sure that a licensee representing a client has and can exercise reasonable skill and care and disclose no material transaction facts to the client, and advise the client to obtain expert advice on matters beyond the licensee's expertise. So just making sure that you are the role of the agent and that you engage professionals when necessary. So moving on to how do you identify when a probate is required? Looking at just 6 typical scenarios, right? First scenario being sole ownership in a decedent's name, right? Is a probate required in this scenario? Most likely, right? If it's in a decedent's name and it's not in a trust and there's no joint owner, there's no joint tenant, right? There's no spouse, it most likely will have to go through probate. And so in Nevada, there are actually different pathways, probate pathways. And the most common one that you guys have all heard of is a general probate. And a general probate takes no less than 3 months in the state of Nevada. A general probate is for estates that are $500,000 or more. And it has specific notice, timing requirements, and that those have to be considered when entering into a listing agreement and opening escrow. Nevada also has a summary probate procedure, and that's a shortened probate procedure, and that's for estates that are worth between $150,000 and $500,000. When you're most likely dealing with entering into these listing agreements and looking at the value of these estates and whether or not it's a summary or general probate, those are matters you can kick to the probate attorneys helping with the transaction. Those are things where you can ask how long is it going to take and what notice requirements are there. A summary probate is actually less time because of the amount involved, and so your notice requirements are shorter. You don't actually have to publish the first hearing date where the personal representative or executor is appointed by the court. And so you actually have 45 less days. So it's a shorter probate. But then there's also in Nevada set aside procedures and small estate procedures. And we'll move on to those at the end of this slide. But moving on to number 2, right, is probate required in a joint tenancy or survivorship ownership? And that's no, right? Title transfers to surviving joint owners by it transfers by operation of law. So all you really need is an affidavit of death of joint tenant or owner, and a full probate is not required. Moving on to property held in a trust. If property is actually titled in the name of the trust, a Nevada probate is not required. So what happens here is the successor trustee, whether or not that be the surviving spouse or another grantor of the trust or a successor trustee named in the trust, steps into the original grantor's shoes and has the authority to manage trust assets. So that includes entering into listing agreements, purchasing agreements, selling properties. The one thing you always have to look for is the property titled in the name of the trust. That's really going to tell you whether or not that asset is subject to probate. So now looking at a recorded deed effective at death. A deed upon death is another scenario in Nevada where probate is avoided. The owner of the property sets up a deed, and that deed is recorded prior to death, and it designates a beneficiary and says upon the death of the property owner, the property automatically passes by operation of law to that person named as a designated beneficiary. Again, that's a recorded document, and a death certificate needs to be presented and recorded with the county, and then title vests in that designated beneficiary's name. considerations that you always have to be weary of are title and escrow issues with being able to sell a property. There's prolonged periods of time where title will not be issued, insurance policies will not be issued based on a recorded deed effective on death. So those are considerations to make sure you're aware of. Now, looking at community property considerations, we already looked at survivorship ownership and joint tenancy. So most of the time you're looking at how title is vested, and that's if it's husband and wife. Joint tenants with right of survivorship is community property. The consideration here is you can only give away or gift your ownership in the property. You can't give away your spouse's community interest in a property. So just know that probate may be required in that situation if you come across the fact pattern where a spouse has given their interest in community property to someone other than their surviving spouse. And so lastly, looking at whether or not a probate is required for small estate and set-aside procedures. Those fact patterns are specific to when you're looking at a small estate affidavit. That's an abbreviated probate procedure where you can transfer up to $25,000 in an estate. By virtue of a small estate affidavit, there's no court approval required. And you have to wait 45 days for anything to transfer under a small estate affidavit. A set-aside procedure is something a little different. A set-aside procedure also has to have specific fact patterns where the amounts of between $25,000 and $150,000 can be set aside to the surviving spouse or minor children in an estate, and that does not require a full-blown probate, just a set aside where the property itself meeting those values is set aside to the surviving spouse or the minor children without the need for a full-blown probate. So being able to identify these different things is something I'll help you go through in the preceding slides. But moving next to probate vocabulary, just looking at different terms that you will see when dealing with probates in general in Nevada. One is the decedent. Pretty self-explanatory here. The decedent is actually the person who died. Looking at what an estate is. So the joke around our office is people say, I don't need an estate plan because I don't have an estate. I don't own a house. Well, once you have a bank account, once you have a car, you have an estate. So they're all of your assets and obligations that are administered after your death. And so looking at estate specifically in this context is the property, the real property that we're looking for to list in your listing agreements and to put in your purchase agreement. So that's part of an estate. Now, this is where things get, I would say, persnickety, right? The personal representative is actually the person who is nominated as an executor under somebody's will, or it is the actual administrator appointed by the court. So a will in Nevada only speaks when a will is probated with the court. So if somebody has a will, that subjects them to probate. If somebody has a trust, you are generally not subjected to probate. So trustees and successor trustees follow a trust agreement. An executor or administrator follows a will. So those are different terms in the trust and estate world, where you're looking at trustees follow trust agreements, and executors or administrators or personal representatives follow a will. And again, a will does not speak until a court says it speaks. So if you have a client who says that I am the nominated executor under a will, what you first ask for is, where are your letters of administration where the court accepted the will to probate and appointed you, accepted, right, the nomination of you as an executor, and then appointed your client as the person who is available and approved to enter into an listing agreement and sign a purchase agreement. So moving on to executor, the executor again is the person that the decedent named in the will, and then that person is thereafter appointed by the court. So an administrator is usually the person who the court appoints when there isn't a will. So when there isn't a will, there's also probate, right? Um, Clients may have decedents may have a will, and that will nominates the person who is given authority to proceed as the executor or administrator into the estate, and the will also says who the estate goes to. So who the estate goes to, right, are beneficiaries, the people who are named there. The beneficiaries are not your clients. The heirs are not your clients. The client is the administrator or the executor that has been appointed pursuant to court order. Those are the people who can enter into agreements with you, and those are the people who can direct and have the approval and authority necessary to conduct these sales that you guys are going for. So an interested person under Nevada law is someone who is interested in the estate and that notice or a court order would affect. So Nevada law requires notice be given to all interested persons of an estate. And so that includes beneficiaries, that includes creditors, right? And so once you get into this probate world, and people say probate is right, that's the time consuming, you pay us too much money, and it's time consuming. And so when you're looking at it, there are certain notice requirements, there are certain time periods, and then all of those things have to be discussed with the client to say that, look, if you get a all cash 10-day close offer in a probate, you're not going to be able to accept that unless you do things ahead of time. So going back to our list here in the probate vocabulary, we're looking at letters. So letters are there are letters of administration. They are the order from the court that gives the authority to the personal representative or executor to administer the estate and to act on behalf of the estate. So that certified copies of those letters are what escrow asks for to be able to close. So you want to be able to get letters ahead of time from your client, so from the probate attorney, and know that certified copies are required. So those need to be ordered early. Moving next to identifying who is the seller. So in a probate transaction, who is the seller? So before you sign a listing agreement, what you guys need to identify is who is the record owner shown on the deed, whether that owner is deceased, right? Then who the appointed personal representative is. And then you need to see what the scope of the authority is for the personal representative. So then also looking at, right, the seller, you need to verify, are there any co-owners, right? Is the property titled in the name of the trust? And are there any other business entities or marital interests involved? One red flag to consider here is a client who comes up to you and says, everything is okay, all the heirs agree, right? That doesn't necessarily mean that the seller has the authority to sell, right? As I said before, the heirs are not the people who grant authority. Heirs are able to object to a sale, but your personal representative appointed by the court is going to be your seller. That is going to be your person. And so in a trust, it is your trustee. And you present a certificate of trust to title and to escrow, which verifies the authority of that successor trustee to engage in this transaction. And something to look at and coordinate with the probate attorney and with escrow and title is you want to make sure that the correct seller name and signature block be approved ahead of time, right? For again, by title, escrow, and probate counsel. So you want to avoid describing an individual as an owner personally when that individual is acting only in a fiduciary capacity. So you want to say that the seller is the successor trustee or the seller is the personal representative, right? Those are the scenarios that you have to make sure in entering into those listing agreements when you identify who is the seller. And so looking next to what documents in a probate should you receive before the listing. And so what you want to get with your transaction coordinator is a death certificate. You want to make sure that you have the current vesting deed. You also want to show that you have the preliminary title report so you can see whether or not a certified letters are required and whether or not, certified letters and the court order opening probate are required, as well as whether or not a certificate of trust is required. Again, getting these documents beforehand would make your transaction go much more smoothly. So looking also, is it under a will or is it under a trust? So again, under a will, you're looking at probate, and under a trust, you're looking at no probate, just a successor trustee authority under a certificate of trust. So again, look for the petition for appointment. Has probate been opened? Because one thing you need to do, full stop, if a probate hasn't been opened, you're not ready to enter into a listing agreement, or you need to know from the probate counsel whether or not a petition for appointment is pending and whether or not that court hearing date has been set. So if it has been, what you're looking for next is that order appointing the personal representative and the current letters of administration. And so both of those things are going to need to be given to escrow for closing. So you need to have both of those things. And you also should have the order appointing the personal representative and the letters so you know who can enter into the listing agreement. Then the next thing, looking at the order, is whether or not your client, in this case, the personal representative, has been given independent administration authority. So in Nevada, we follow the Independent Administration of Estates Act, which is your friend, right? So that gives the client the authority to sell the property during probate without court approval. So it's important. You don't have to wait for court approval when a client has the independent administration authority. There's also the limited authority in an estate, or there's the traditional probate where you have to receive court approval of the sale and then you're subject to overbids. Then also looking at getting the inventory and appraisal information, which will affect your sales price. Clients are always confused, and I'm sure you see this on a daily basis, about a broker's opinion of value versus a CMA appraisal versus what is needed in a probate. What is needed in a probate is a CMA appraisal, and those are needed because one, it sets date of death value for a step-up in basis for tax purposes, but two, in an independent administration, you need to have an appraisal so that you can show that any offer received and approved is above 90% of that appraised value, and then there's no court approval necessary. So then the last thing that you're looking for before listing is any other court order that is restricting the sale or the representative. Again, this is when a probate requires special notice or requires court approval, or that the representative has limited authority. So going back to really the two mechanisms for paths of sale and probate. One, we're looking at the Independent Administration of Estates Act, and then two, a court supervised sale. So under, again, the Independent Administration of Estates Act, your personal representative, your client, must receive appropriate authority. There's either full or limited authority. Again, full authority may permit a sale of the property without court confirmation. This is huge because um, court approval takes time. So you have to notice the hearing, you have to wait for an overbid, and you have to then receive final court approval of a sale. So it takes a long time. But if you know that your personal representative has independent authority, then all it actually takes is 15 days notice. So you have to give notice to all of the heirs. You have to give them an opportunity to object. And if they don't object, your client can move on with the sale without court approval. So it's an important question to ask and to coordinate if you are at the beginning of the probate process. A little harder if you're in the middle of it and your client presents, right, with saying that I have limited authority, or this is a general probate and we require court confirmation. So that is the court supervised sale. So a client will have to petition the court, and then there's notice and publication of a hearing. So, and then you request what the drawback is that you can at the hearing to approve, right, your contract, you risk an overbid. And so that's a problem when you have a buyer and seller and you've entered into a contract and everyone expects for this to close, and you're somebody comes in with an overbid. Good for you if you are the selling agent, but bad for you if you're the buyer's agent, right? And so you want to see whether or not at the beginning, early and often, if there's an independent administration for your personal representative, or whether or not it's subject to a court supervised sale. So Nevada statutory notice, right, expressly distinguishes between full and limited authority. So that's something you also have to look at, because limited authority does not permit an unsupervised sale or exchange of real property. So again, looking at independent administration, right? So again, full authority does permit the sale without court supervision or approval. Limited authority does not provide for an unsupervised sale and or option to purchase a property. So under limited authority, court order controls, and the authority can be conditioned, restricted, or changed. So again, full authority versus limited authority, those are the two things to look at with a personal representative. So looking at next, the full authority sale. So under full independent authority, the representative generally may determine the sale method, price, and terms. So the only thing that this requires is the notice of proposed action to all beneficiaries. So under a full authority sale, your personal representative through probate counsel prepares and gives a notice of proposed action to all beneficiaries. So that the personal representative sets the sale method, the price, and the terms. So, and this is important because it authorizes the personal representative to have significant flexibility to enter into a contract, and then can close on a contract with giving 15 days notice to beneficiaries. And again, if those beneficiaries don't object within 15 days, then the sale can move forward without court approval. One red flag here, though, a critical exception, is that if the property is being sold for under 90% of the appraised value, then all interested persons must consent in writing, and the sale must be approved by the court. So that's one red flag in a full authority sale. So again, on your notice of proposed action, that is going to let the beneficiaries know the price, your commission, and how that commission is calculated, what the inventory value was, so what the appraised value was, and then let beneficiaries know of their objection rights. So again, that's 15 days. So account for the 15 days from when the notice of proposed action goes out. You have to give those beneficiaries 15 days to object. So again, timing and working with your client on when you can actually close on that, account for the 15 days. So looking at next, court
Jamie,
confirmation.
real quick, is that business or calendar days?
So those are calendar days, 15 calendar days.
Thank you.
No problem. So looking next to court confirmation. So when is court confirmation required? Court confirmation is required when there's a general probate, when there's only limited authority given to a personal representative, and when there is an objection received to a notice of proposed action. So a court confirmation requires a lot, right? It requires that you publish notice of the contract, and so of your purchase agreement, and you set a hearing on that purchase agreement, and that is noticed. And then after that, there's a hearing set, and that's the risk for overbid, right? But a lot of times people don't show up to court, but I'm sure you all have been there when there are overbids, and that does happen. And so people can be overbid during a hearing, and then that sets just the time period for closing all the way back, right? So, but just know that court confirmation is required in those scenarios, again, when there's a general probate, when there's limited authority, or when there's been an objection to a notice of proposed action under a full authority. So it's just, again, that your buyer needs to understand that the acceptance may not guarantee closing, that it is subject to court confirmation. So really, then the next thing to consider is really, you don't promise a buyer that property is secured merely because the personal representative accepted that offer. You have to make them aware of court confirmation, and coordinate the deposits, the hearing attendance, the overbid mechanics, and the closing deadlines with counsel and with escrow.
I have a
Um,
question, Jamie.
yes,
So
yes.
is it always up when it does get to that point and there are competing bidders that could come in and overbid? Is it always up to the judge how much they can come in? Is it always a certain amount that they have to overbid?
So usually the judge at the beginning of the hearing sets the overbid amount. So he or she sets what the overbid can be, right? And so normally, you would look at between $500 and $1,000 increments. It's something that you can ask for in advance of the hearing too, to see what those overbids can be. But anybody can come in and really offer anything. I was in a probate in Washoe County where it went. It was a property on Lakeshore, and it went significantly over, and the overbid process was wild, and it actually went for well over what my client, who was the buyer, was willing to go. And really, the judge, actually, the gavel fell. He accepted my client's last bid, but then another proposed buyer came in after the gavel fell, and we were detailing the terms of the agreement, and offered more. And the probate attorney on the other side said it's within the best interest of the estate to take the highest and best offer, and pled to the judge to accept that offer instead. And the judge ended up taking that offer. So
And we
um,
just actually had that question. Are they required to take the highest offer?
so they are. So once you're in court, if it is the highest and best offer, based on the terms, the judge will take the highest and best offer, right? So, but again, the terms have to be stated too. And
Hmm.
just because it's an overbid on price, one thing that you would need to coordinate with the probate attorney is looking at the what the closing date would be, whether or not it's cash, what the likelihood of closes. All of those things would need to be considered. It's not just an overbid. So
Hmm.
those things would need to be looked at as well.
Thank you.
No problem. So looking now to, right, appraisal and pricing. When you look at appraisals and pricing for probates, one thing is looking at, there's just confusion among valuation concepts, right? So in a probate, a personal representative has to do an inventory, and they do an inventory of all the estate assets, and then they get an appraisal of those assets. And so that is required to be reported to the court. And we know that differs from a broker comparative market analysis, and we know that significantly differs from a buyer's lender appraisal. So knowing those things, that in a probate action you are going to have, right, 3 different appraisals. Um, Also looking at appraisals, and looking at what the market value is. That differs really in a trust administration, because in a trust administration, we're looking at to get an appraised value for a step up in basis, and also looking at trust distribution. If you're giving the house to one child, what is the fair market value of the house at the time of the death, so that you can give the other beneficiary the equal amount. Or that the surviving spouse goes to sell that property, what is their step up in basis? So, getting appraisals is important, but also knowing that things differ. If you have a client who is a surviving spouse, they're the successor trustee of the trust, or they're the beneficiary under a right of survivorship. They go to sell the house, and they need to get an appraisal for the step up in basis, but you end up selling the property within 9 months of the date of death. You can actually use the sales price as the fair market value, and so you would need to get a separate appraisal. So knowing that in probates and estates and in trusts, we've got different consideration for appraisals. Looking at really the practical considerations regarding pricing, looking at condition and deferred maintenance on a property. What we see quite often, and where I get involved, is when you're looking at occupancy and access. Who is the occupant after a decedent died, and can they provide access? Knowing a lot of the time that the person in the house is not the personal representative or the trustee. And so those are things you need to look at early within a listing agreement and purchase agreement, and really consider when you're setting a price. Also looking at what the carrying costs and the creditors are. So when you're looking at a probate estate, beneficiaries take subject to an encumbrance. And so whether or not you're in a probate or a trust administration, you're looking at what the creditor pressures are, and who can continue paying for the costs, the carrying costs for the property. And then really looking at what the court and notice requirements are, because if this is going to take 6 months, when there's going to be court approval necessary, we're looking at least like 3 months. And that's if everything goes well, your clients are responsive, they've given you all the required documents. We could get a probate done in less than 3 months, or 3 months at the very least, but normally that doesn't happen. So you need to know ahead of time really what those notice requirements are, and set your price accordingly. And also, a personal representative does not represent an heir specifically or beneficiary specifically. They have to act within the best interests of the estate. So you have to consider all of those things when setting your price and then accepting an offer. The acceptance of an offer is not subject to heir really approval, right? Unless they object to the sale and their objections are reasonable at a hearing. They don't have to approve a personal representative entering into a contract. So just being aware of that. So just knowing that the valuations serve different purposes, and your job is to document, right, the marketing rationale, showing activity, offers, price reductions, repair decisions, and material feedback. And so, a complete file really helps you with dealing with the representative and helping me explain why, right, the proposed sale benefits the estate if we do come to court approval. So next, looking at listing agreement issues, right? So you want to make sure that your listing agreement addresses who the personal representative or trustee is and their signature capacity, right? The effective date and their authority to engage the broker. Do you have in a probate your letters of administration and your court approval opening probate? So you need to know when you actually have authority to engage, right? To engage your broker here. Then you want to make sure whether or not in your listing agreement there's the requirement for court approval and what notice contingencies you have. And then also the commission and how is the commission calculated, how was it agreed upon, and there could be court approval and review of that commission should it fall outside of reasonableness boundaries. And again, in a notice of proposed action, a beneficiary or an interested person in a probate may object to commission. So just being aware of that in a listing agreement. Also, considerations for access, occupants, personal property, and then security, having those things secured once there's no one in the home or people in the home that are not the personal representative or trustee. Then also you want to consider your repair authority and the expenditure limits. Again, when you're in a probate, the personal representative must receive certain authorities to move forward. So authorizations to move forward, certain expenditures. Sometimes they don't have any money to continue the payment for carrying costs and expenses. So being aware of those. And then just really knowing what the required notices and communication protocols are ahead of time. I said this multiple times, everything needs to be thought about early, and often probates don't go quick. So once you're in a probate, everything is statutory. The notices are statutory, the hearings are statutory, and everything is based on court availability. So when you're now looking at purchase agreement drafting points, you want to use your forms and addenda that have been pre-approved by the broker and counsel. Don't create legal contingencies from scratch. Ask about them if you're not aware, right? If you don't know whether or not your client has full authority or limited authority, ask probate counsel what your addenda should say about whether or not court approval is required, and let your buyer know that there is notice that's required, and then there's an opportunity for the interested persons to object. And if they don't object, we've got 15 days, great, and you can close after those 15 days. So you want to be aware of that. So make sure you always, again, going through these quickly, have your seller's fiduciary capacity, that you receive your court confirmation if it's required, whether or not there is notice required under the independent administration and objection period, and whether or not the sale is subject to the representative's legal authority. And then be flexible on your closing dates because you might need them. And then make sure that you make your buyer aware that there could be confirmation or overbid procedures by the court. So always take into consideration property condition and inspections. And then what happens to the personal property at closing? Whose responsibility is that? And I know you guys all work with your clients on how to determine that. But in a probate, there has to be an inventory, and the personal representative can obviously distribute things out, but there usually has to be approval from the beneficiaries in doing so. And also know that there's no early occupancy without express approval. So again, use your forms and ask questions. Going next to disclosures, and this is something that you probably see often. So with Nevada, there is your residential disclosure form, and when you're looking at probates and you're looking at trusts, whether or not there is the requirement of disclosures, and whether or not your personal representative or trustee has to give those. And Nevada says that they don't, right? If there is, they're only temporarily controlling or holding the property solely to facilitate a sale. So know that you need to look at the fact pattern. It needs to be specific, but you need to make sure you notate the exact exemption that's being claimed. And sometimes, say there's a trust, and then there's a trustee who does not occupy the property. However, they have a beneficiary who's been occupying the property, and the trustee knows specifically what repairs have been done, what condition of the property is. Known material facts still require, right, careful handling and disclosure. So agents should not complete the seller's form for the seller. And really, inspection opportunities and written disclosures remain important. So know that the disclosure requirements are fact specific, and that NRS 113-130 does not eliminate a licensee's separate duties. So your client must disclose known material transaction facts and advise, right, the use of experts for matters outside of the licensee's expertise. So again, fact specific, and ask your probate counsel if you have a question. Moving next to condition and occupancy. So ask early, right? Possession and personal property frequently delay probate listings. An heir or an occupant may not have the authority to grant access, remove property, negotiate rent, or agree to vacate. Your personal representative or your trustee has the authority, not an heir, right, or an occupant. So, if you have a question, refer your occupancy and removal questions to counsel. Ask questions. It's better to ask those questions ahead of time than really have these things come up later. So, and ask the questions early. Moving on to really probates and the title and escrow checklist that I deal with. A preliminary title report is a good starting point. It's not a guarantee that all probate requirements have been satisfied. You want to ask title what documents will be required to ensure the transfer, and whether court certified copies must be recorded. As I said at the very beginning, know ahead of time, let's just say even 10 days before close, to get those certified copies, because the certified copies have to be requested by the court. The court has to grant them, and having your client have to run down to the court to get those things, it's possible, but if you do it ahead of time, title's always going to ask for them. So know that ahead of time. Looking at this title and escrow checklist, know that I'm going to give you a reference guide, and also just a short 2-page checklist that'll summarize this presentation so you can look at things. But really, you want to make sure you have the correct vesting and legal description. You want to identify the deeds of trust, liens, judgment, and taxes. You want to know, are you subject to an HOA? And then you want to know if there's any estate claims or payoff demands, creditors' claims. Those things need to be known ahead of time. And then, right, I'm dealing with a probate right now. We've got multiple estates. The husband and wife died within a year of each other, and we've got different things to deal with. Things that are subject to probate, some things that are non-probate transfers. So you may be dealing with multiple estates and deceased co-owners. So know those things, and then look at what recorded notices or litigation there is, and whether or not there are required certified court documents. Your title is going to tell you what deed form and fiduciary signature block you need, but just know those things ahead of time. And when you have a preliminary title report and there are hyperlinks to the documents, click on those hyperlinks, read the documents. It's important. It's important to know. And if you have questions, ask those questions ahead of time. What do these things mean? So, now looking at really what the transaction timeline is, you want to look and confirm title and the probate status. You want to confirm appointment and sale authority of your personal representative. Then you want to obtain valuation and prepare the property for listing. Then execute your listing with your personal representative or trustee in the correct fiduciary capacity. And then you'll obviously do your marketing and your document activity. Your offer that you select needs to be based on the required procedures. So whether or not that is a full authority under the Independent Administration of Estates Act, or whether it is limited authority with court approval, or an objection to a notice of proposed action which requires court approval, know that the offer that you select has to abide by those things. And so the next step would be completing the notice and consent, and then that confirmation process, and then resolving any title, closing escrow, and then preserving your transaction file. So again, the transaction timeline may overlap, the sequence may overlap, but authority and title work should begin before your marketing. You need to explain that to buyers that probate timing is driven by legal procedure, not simply by the lender or inspection guidelines. So it's authority, marketing, offer, approval, close. The common failure points that we see, are unauthorized listings, that you have the wrong signer, or that there are missed restrictions. So, when I have to get involved, it really is, has there been an objection received, whether or not we've gotten the required documents to escrow, and then really it's authority, who has the authority to sell, and when they have the authority to sell it. So, when you promise court approval or a specific hearing date, you can't promise approval. You can promise there's a hearing date, and then, but know that overbid processes may delay that. So, most preventable problems arise at your intake. And so, usually a short authority checklist is more valuable than trying to repair an unauthorized or unclosable contract later. Knowing that we're coming up on 60 minutes here, I just want to run through, really looking through. I kind of look at things as a green, yellow, or red intake, and really that is when you're ready to list, and that's a green transaction, right? You have current letters, clear appointment, and then you've got sale authority confirmed by counsel or title. You have access to the property and occupancy controlled, and then you've got evaluation and sale path identified. When you're looking at yellow and red, right, you're looking at whether or not you have everything. And to me, it's, if you don't have the authority, if you don't have the path, you can't list right? Or obviously enter into a purchase agreement. So again, looking at your communication, you need to communicate with your client, and you need to communicate with the probate counsel, and you need to communicate with title and escrow. So that at the beginning, identifying that the agent, who you, as an agent, who your actual client is. You need to identify who the personal representative is, who the probate attorney is, and then you obviously have engaged title and escrow. And so, again, looking at with communication, identifying who may authorize price changes and repairs. And then it's not you who communicates with the heirs and the occupants, it is the personal representative or the trustee. And just knowing with the attorney how offers will be presented and documented. And really, I guess with a communication plan, it's looking at avoiding group decision making, right? Unless it is appropriate. So the representative may consider interested persons' views, but as an agent, you should not allow multiple family members to issue inconsistent instructions. I wanted to just go through a practical scenario with you really quick, and just as an example of this, a daughter engages you to list her father's home in Las Vegas. One, Clark County has an amazing self-help probate checklist. So if you're ever interested, you go on the self-help website and familiarize yourself with that. But if you're looking at this scenario with a fact pattern where the daughter comes to you, her father has passed away, and she says, the deed is solely in my father's name. It doesn't have the estate was not in trust. I'm named the executor of my father's will. I don't have I haven't opened a probate. And my brother lives in the property, and I want a 30-day closing. How do you help? What do you need to do before signing the listing? In this scenario, the first thing to do is tell daughter, you need to open up a probate. You need to be appointed as the executor. You need to talk to your brother about occupancy, and let him know that the property is going to be listed for sale. And you need to then start that early before you even enter into a listing agreement. If they engage a probate attorney, it's going to make it easier for you if you ask for independent authority. So the first thing that I would advise that you do is you tell the daughter to engage that attorney to open up the probate, and then you obtain the deed and title report. And you explain to her that just being named in the will does not by itself establish that she has the authority to enter into the listing agreement. So you want to request that she be authorized as the executor, and when those documents will be in effect, and the timing of those documents, and identify the occupancy of the brother, and that's really done through counsel of what those rights are, and really, again, advise that independent administration be requested. And at the very end of this, if she wants a 30-day close, advise her and avoid promising a 30-day close before the sale procedure is known, because you're not going to know what the sale procedure is until she's appointed as personal representative. Knowing that we just hit an hour and a lot of you guys probably need to go, what I have for you is a probate sale checklist. And so I can Jessica can make that available to you tomorrow. She can also give you a list of, I have listed NRS procedures that you can look at if you have questions, and also my contact information, so that if you have questions regarding probates, regarding trust administrations, and entering into these contracts, you can ask me those questions, and I can help you through those if you have them. But just taking the takeaway from this that I want you guys to have is that there's not really any one clear path to probate. In Nevada, there's varying paths, but knowing intake at the very beginning, knowing questions to ask at the very beginning, and identifying who has authority to act and when, and what notice requirements are, will make handling probates much easier. So in working with your escrow and title professionals to know what you need early in that process. I didn't know if anybody wanted to open this up to any questions, any specific questions, but I am
We
here.
do have just a couple of questions that were in
Okay,
the
great.
chat.
Okay, thank you,
Back to the overbidding. I think that was the
okay.
that was the jewel of the
Yes.
presentation. So, does the bid have to be all cash, or can it be a loan for an overbid?
No, it does not have to be all cash. It can be a loan, but one of the things that I've seen is if you're coming in and there's an overbid, one of the things that you can ask the probate attorney to require is pre-approval. Right. So if somebody's coming in with an overbid and it's not, they need pre-approval.
Awesome. And then can you very briefly just tell us how it's determined if a property is subject to an overbid?
Oh, so that is when there's court approval,
Got
right? So if you if there is if your personal representative or executor does not have full authority under the Independent Administration of Estates Act, or if there has been an objection to your notice of proposed action, then you at this point you've accepted, your personal representative has accepted an offer. That offer has to be noticed in a hearing. So you say, you propose the notice of hearing where you say that the court confirmation of the sale is the subject of the hearing, and you would, the buyer and the seller come to the court hearing, and you present the offer for court approval, and then the court at that hearing sets it, and says, are there any persons present who wish to submit an overbid?
Awesome. Thank you, Jamie, so much. I don't see any other questions in the chat, but I will definitely make sure to pass all of the information that you're going to be sending me. I'll pass along to all of our participants today, along with your contact information, so they can contact you directly if they have any questions. And wow, that was a lot. I've been through one probate and representing a buyer, and the overbid process did occur because the heirs did not agree.
Right.
Yeah, and they got overbid and unfortunately lost the property. And it's a grueling process. It was probably a good 6 months. So
Right.
always just have someone like Jamie on your side who can walk you through the process and make sure that you've got the right people signing, and you've got all the documents that you need. And of course, you can always call Jenny too. Jenny's been through this a bunch. And has worked with Jamie a lot. So you've got some good resources at your fingertips. But thank you, Jamie, so much. That was amazing. We really appreciate you and your time. And looking forward to, learning more about probate. Maybe some of these agents on here will get after some of those. We'll see.
Absolutely. And again, any questions, my contact information, give me a call ahead of time. Questions ahead of time are always welcome, because as most of you know, attorneys get a bad rap. We don't create the problems, but we help solve the problems. I like to say. So if you ask me the questions ahead of time, it usually is better.
Awesome. Thank you, Jamie, so much. Thank you, everybody, for attending, and we'll make sure to send the recording and all the documents tomorrow.
All right. Thank
Have
you,
a good
Jessica. Thank you,
afternoon.
everybody.